attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first lawcast in a series discussing Sections 16 and 13 of the Securities Exchange Act related to insider reporting requirements and the Section 16 short swing trading rule. Sections 13 and 16 are individual SEC reporting requirements for officers, directors, and greater than 5% shareholders of publicly reporting companies. Section 13 requires any person or group who directly or indirectly acquires beneficial ownership of more than 5% of the securities of an Exchange Act reporting company to file a statement with the SEC disclosing certain information. Section 13 is a key provision that allows shareholders and potential investors to evaluate changes in substantial ownership. The statement filed is either on a form Schedule 13D or 13G, and the schedules must be amended in the event of a triggering change to the information initially filed. Section 16 of the Exchange Act requires officers, directors, and 10% shareholders of an Exchange Act reporting company to file certain reports of security holdings and transactions. These reports include an initial Form 3 and ongoing Form 4s to report acquisitions and dispositions of securities. The Sarbanes-Oxley Act accelerated the reporting deadline for most transactions to 2 business days and mandated that all reports be filed electronically on the EDGAR system and posted to the company's website to facilitate rapid dissemination to the public. Section 16 is also designed to discourage trading on inside information and presumes that certain people inevitably will benefit from their insider status. Accordingly, any purchase and sale of securities by an officer, director, or 10% shareholder during any 6-month period can be matched, and any resulting profit is recoverable by the company, and if the company doesn't pursue the action, a shareholder can pursue it on behalf of the company. Neither Sections 16 nor 13 require intent or contain any subjective standards. The failure to file, regardless of an explanation, is a violation. On September 10, 2014, the SEC filed 28 separate actions against officers, directors, and major shareholders, and an additional 6 actions against reporting companies, all stemming from violations of the reporting requirements contained in Sections 13 and 16. The SEC announced that it had created a task force to investigate violations using quantitative data sources and ranking algorithms to identify violators. The SEC settled with all but one of the charged for a total of $2.6 million in penalties. Historically, the SEC has rarely pursued separate actions for violations of Sections 13 or 16. Rather, such claims would generally only be included coupled with other claims such as fraud. However, in keeping in line with the broken windows policy and using technological advances to monitor, the SEC stated in a press release that it intends to vigorously police these sorts of violations through streamlined actions. Moreover, in the past few years, a whole crop of plaintiffs' attorneys have put monitoring systems in place to review all Form 3 and 4 filings under Section 16 and to catch short swing profit trading violations. These attorneys managed to quickly find a plaintiff shareholder to pursue the violation, and they're not afraid to file suit. Violations carry a strict liability standard and allow for the recovery of attorney's fees, so even the smallest cases are winners, and some attorneys have built an entire practice on these cases alone. It has become increasingly important for individuals to be aware of and comply with their Sections 13 and 16 reporting requirements. In the next lawcast in this series, I will begin to drill down on the specific reporting requirements under the rules and explain the added short swing profit prohibition under Section 16. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.